This is OwlUp, where learning happens in minutes, not hours. For a deeper journey, explore all our courses at owlup.co. Now, let's dive in. Welcome back to Your Legal Rights. I'm excited to dive into Chapter 2, where we're talking about everything you need to know about your rights at work and what's expected of you as an employee. We'll cover the essential protections you have and the responsibilities that come with your paycheck. Let's get into it. Right now, somewhere in the world, a worker will not come home from their shift. That's how dangerous some jobs still are, even in modern economies. You sign a contract, you show up, you work hard. But whose rules are you actually playing by, and how much power do you really have? You already know turning up to work isn't just about doing tasks safely under a signed agreement. Beneath every rota, payslip, and performance review sits a legal structure that quietly decides what's normal, what's negotiable, and what's outright unlawful. Most people only meet this structure when something goes wrong: a missing payment, a sudden dismissal, a promotion that never comes. But by then, they're reacting, not choosing. Think of how you check your bank balance before spending. You want to know what's guaranteed and what's at risk. Employment rights work the same way. Some protections follow you into any job. Others only exist if you or your coworkers insist on them. Over this series, we'll unpack how laws, contracts, and workplace policies interact, so you can spot when a request from your boss is a fair instruction, a negotiable ask, or a red flag. Zoom out for a moment from your own job and look at the global picture. In some countries, the law guarantees maximum weekly hours. In others, it barely notices how long you're on the clock. Some systems assume you can be fired with almost no explanation, while others demand a documented trail of reasons and warnings. These differences aren't abstract. They shape whether you feel disposable or secure when you walk into work. It's like following a recipe in different kitchens. Same dish, but the tools and ingredients you're given can radically change the result. Start with the foundation: statutory rights. These are set by parliaments, congresses, or regulators: minimum wage, anti-discrimination rules, rest breaks, parental leave, holiday entitlements, and core safety standards. You don't have to earn them, and you can't sign them away, even if a document in your onboarding pack seems to suggest otherwise. A clause that undercuts a legal minimum is usually void. The law silently steps in and replaces it. Layered on top are contractual rights, what you personally agree with your employer. This is where details live: job title, pay rate above any legal minimum, bonus schemes, remote work rules, notice periods, non-compete clauses. Here, wording matters. May be eligible for a bonus is very different from will receive a bonus of X% if Y target is met. The first is discretion, the second is a promise. Technology has made these promises more slippery. Click-through offer letters, app-based schedules, algorithm-set targets. But a commitment in an email or HR portal can still form part of your contract. Then there's the collective or judge-made layer: union agreements, tribunal decisions, and court rulings that interpret gray areas. A union contract might tighten what counts as reasonable overtime or just cause for dismissal. Courts fill gaps by asking, in this sector, what would a fair, informed person expect? That's how principles like protection from arbitrary pay docking or harassment standards often emerge and evolve. Now add a modern twist: platforms and gig work. The app calls you an independent contractor, but the law might not agree. Judges look at who controls key levers. Can you set your own price? Send a substitute? Refuse tasks without penalty? The more the company scripts your day through software, the more likely a court is to say you're effectively an employee with access to that whole three-layer structure. Your challenge this week? Pick one real or potential role, yours, a friend's, or a gig you're considering, and map it. What would be non-negotiable legal rights in your country? What extra protections could a union or staff association add in that sector? And which points in an offer or app screen would you push to rewrite before tapping Accept? Think of a fintech startup rolling out a new bonus scheme. On launch day, the CEO emails, Everyone will receive a 15% bonus if we hit revenue target X. A month later, HR quietly updates the intranet to say, may receive up to 15% at management discretion. Those two lines can mean the difference between an enforceable promise and a polite aspiration. In court, screenshots and timestamps start to look a lot like bank statements, a record of exactly what was credited to you and when. Or take a ride-hailing driver whose app suddenly imposes a new acceptance rate threshold. No one says you're now on a performance plan, but if refusing rides leads to fewer shifts offered, that digital nudge can be treated like an unwritten rule. Tribunals increasingly ask, would a reasonable worker, seeing these patterns in the data, believe their choices were truly free? Even workplace norms can harden into expectations. If your team always leaves by 6 p.m., a manager demanding 10 p.m. finishes every night may need stronger justification than one in a 24/7 trading desk. Laws now chase work across borders. A coder in Lagos can be hired by a firm in Berlin, paid via a platform in San Francisco, all before regulators agree which country's rules apply. As AI starts assigning tasks, setting targets, even screening applicants, some cities treat algorithms like junior managers that must follow due process rules. Climate reporting is next. Think of firms auditing supply chains the way marathoners track split times, checking which links quietly run on overworked labor. Laws will keep shifting as remote work, AI tools, and climate rules reshape what a job looks like. Think of checking your payslip like scanning a restaurant bill. You're not just hunting for mistakes, you're noticing patterns. Extra fees, missing discounts, quiet changes over time. Curiosity is your leverage. The more you notice, the more choices you actually have. Before next week, ask yourself, do I clearly understand my core rights at work? Like how overtime is calculated? What my contract actually says about notice periods? And what protections I have against unfair dismissal? And where do I see possible gaps or gray areas in my situation right now? If I needed to raise a concern about discrimination, harassment, or unsafe working conditions tomorrow, who exactly would I go to first? What policy or grievance procedure would I follow? And what evidence would I already have or need to start collecting? Looking at my current job, are there any responsibilities I'm taking on, like extra hours, duties outside my job description, or working through breaks, that might be crossing from normal flexibility into potential exploitation? And what boundary am I willing to set this week to test that? This was OwlUp, your daily step forward. To keep learning with structured courses and more insights, go to owlup.co. Until tomorrow.